Take a lot of indulgence in making a motion. My lord, part 2, item 1, we have fixed the item for hearing today.
What happened?
My lord, I have gone through the case report, and this case is an appeal against acquittal under Section
acquittal.
4 of POCSO Act.
Uh-huh.
So the imprisonment can go up to life. Life imprisonment.
Yes.
So, as per the Guwahati High Court rules, whether it should be laid before the division bench or this court can take it
No,
up.
it is, no, this is against this thing, isn't it? It is, though it's imprisonment for life, look at the Guwahati High Court rules.
In,
It
punishment
is
is
for more than
10
10 years against the imprisonment, not in acquittal. Anyway, you find out, I'm not very sure also, because in the Guwahati High Court,
The previous case that we have, my lord, which was heard by Justice Michael,
huh?
the case was referred to a division bench that was under Section 6 of POCSO Act.
Okay, so Section 6 against acquittal.
Yes, my
Then I think it has to be also, if it's life imprisonment.
lord. But this one is under Section 4. However, the punishment can run up to life imprisonment.
Up
So,
to life. For how long has he been imprisoned here?
It's acquittal, my lord.
Acquittal, up to life.
So I'm not sure whether it should be before division bench or this one.
You study? We'll fix it for some other day. We'll see. Instead of passing an order straight away, we'll adjourn it. I'll also have a look. Okay. It's 302. It's the 302 case. I have a look.
This
302?
this case, my lord. No, it's POCSO Act.
POCSO.
POCSO.
Okay. We'll have a look. We'll adjourn it so that we don't make a mistake. On the submission made by the learned counsels. Who is for the amicus?
The Rosang Zwala, he's supposed to be here, my lord. I have informed him.
On the submission made by the learned PP. This is matter in the next week.
All right.
We'll just have.
I seek a loss of indulgence in making a mention on this that item, my lord. Maybe for today or tomorrow, this writ petition, I would like to see for withdrawal with liberty. There is some
Withdrawal of the writ
Yes,
petition. Okay, we'll list it tomorrow.
Yes, my lord.
For admission, item number 1.
May it please your lordship. As per the order of this court, 29/4/2025. My lord, this honorable court has observed that if there is no positive indication with regard to the compliance of the court's order, the personal appearance of the respondent concerned may have to be directed.
Issue notice to the newly impleted respondent number 7.
Respondent
Yes,
number.
so who is the petitioner? Counsel for the petitioner has taken step for serving.
I am for the petitioner.
So now,
ID card has not returned back from the respondent number 7.
then we'll have to wait for some time.
No, my lord. If your lordship may kindly come to order 29/4 of 2025.
Yes, 29.
29/4 of 2025. Now, the order of the single judge has been upheld by the division bench, and which was again upheld by the Honorable Supreme Court. Now, in the last court date on 29/4/2025, this court has made a specific observation, my lord. Now, payment has not been done till date. The respondent have not complied the specific order of this court. So, at this
But
stage,
who is the person who is to take the steps for compliance?
respondent number 5 and 6 are the chairman and managing director of the NPCC, National Project Construction Corporation.
And
the
who is
zonal
11, the newly impleted?
Newly implemented is the Secretary to the Government of India, Ministry of Home Affairs. Now, the specific direction of this court is with respect to respondent number 5 and 6, in my understanding, as per reading of 29/4/2025. Because
5 and 6 will have to do something. In the meantime, 11 is also sermon, isn't it?
It's not
Newly
11,
implemented,
7, 7, ma'am.
7,
Seven. 7,
So, wait, let's read the order first. What
Manoj.
is this? 29.
I'll read from page
Just
3.
read from.
I'll read from page 3, Malad.
Yes.
Today, Mr. Roshan Subedi, Learned Counsel has produced a communication dated 13/3/2025 written by the respondent number 6. Respondent number 6 is the zonal manager of NPCC. To the Under Secretary to the Government of India, Ministry of Home Affairs, Department of Border Management, New Delhi, which is to the effect that the appeal filed by the NPCC before the Supreme Court and the High Court has been dismissed, and therefore further necessary direction was being sought. Be it stated herein that pursuant to the direction passed by this court in WPC number 71 of 2018, by judgment and order dated 4/12/2019, the Deputy Commissioner Longklai District, by his letter dated 28/1/2020, had written to the NPCC authorities to deposit the assessed amount of rupees 19 crores 18 lakhs 43,087 payable to the petitioners for interest calculated under Section 34 and Section 28 of the Land Acquisition Act 1894. Aggrieved with the same, the NPCC has filed writ appeal and thereafter SLP before the Apex Court. Both their appeals had been dismissed. It was therefore incumbent upon the NPCC authorities not to simply write a plain letter seeking further instructions in the matter, as was done by their letter dated 13/3/2025 produced by the Land Council today, but instead seek for the fund in terms of the assessment made by the Deputy Commissioner Longklai District, with the further mention that further interest would also accrue since the assessment is of the year 2020. Therefore, the communication dated 13/3/2025 produced by the Learned Council cannot be accepted as a step taken by the respondent authorities concerned towards compliance of the court's direction.
What's the letter 13? Dated 13/3/2025 is
was
what?
produced in the last court date by my learned friend, Madam.
Okay, it's here, marked as X.
Yes.
This cannot be accepted.
Yes.
So what is the letter? Just read the contents. Do you have the copy?
I don't
It's
have the
here.
copy.
Okay.
As observed by
Okay,
this
this
honorable
is
court,
written to the, it's addressed to the
Undersecretary.
Undersecretary, Ministry of Home Affairs, for further necessary direction in this regard. Now, this Undersecretary, that means the Ministry of Home Affairs is made a party
Yes, number 7 now.
as respondent number 7.
Yes.
Respondent number 7, he was a party in the writ petition. Now he was made a
So
party.
you're representing them. Anyways, then continue.
I'll continue reading
Just
this. Madam.
continue then this letter is not accepted by this
Yes,
court.
Madam.
Then
Under the circumstance, this court is compelled to contemplate directing the personal appearance of the respondent concerned to personally answer as to why the direction passed by this court has not been complied with, despite the dismissal of the writ appeal as well as the SLP. Mr. Roshan Subedi, Learned Counsel, however, submits that he may be given one more opportunity to secure positive instruction from the respondent, and that the respondent authorities may not be summoned. Considering the said submission, one more opportunity is granted to the respondent to take immediate steps for compliance of the court's direction. Let this matter be listed again on 29 May 2025. It is made clear if there is no positive indication with regard to the compliance of the court's direction by the next date, the personal appearance of the respondents concerned may have to be directed. My Lord, while passing this order, the respondent number 7 was not yet a party on 29/4/2025. So we can see that who are the respondents liable here in this case, as observed by this court, is the respondent number 5 and 6, who is the chairman and the zonal manager. Subsequent to the passing of this order, we have filed an application for impleadment of respondent number 7, who is the secretary to the government of India. Now, my Lord, as we understand,
which department?
Ministry of Home Affairs, Border Management.
Home.
Yes,
Then
correct.
now we cannot ask. He is impleaded in place of which this thing respondent.
Not in his, he is individually impleaded, not in
New
place of
party.
someone.
New party.
Pardon?
He was not the party in the contempt petition.
He was,
He was not a party. Now, the reason why he is impleaded is because this letter marked at X
Yes, 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 correct.
is addressed to the Ministry of Home Affairs.
Correct, Madam.
So it appears that the Ministry of Home Affairs are the ones who have to take steps. Is it necessary steps in the?
Funds has to come from the Ministry of Home Affairs. That's why the respondent was implicated. At this
So
stage,
if we call for the personal appearance, it will have to be from the Ministry of Home.
No, if we look at the order passed by this court on
Look,
29
we
or
look at that
25,
order, huh?
it has to be
May,
the
it's simply
NPC.
may. Huh?
It has to be NPCC because the respondent number 7 has not been made. a
But this
party.
court has referred to this letter, X, isn't it? X is a letter
It has not accepted that letter.
which was direct, it is accepted. Okay, it simply says that simply praying for more time.
Yes.
When the letter is directed to the Undersecretary Home, isn't it?
Lordship
So
is
now
right.
even this court had found it necessary that the Home Department has to be a party. Anyway, so
My lord, I
what,
would
what
like to
steps
bring
have
to
you
you,
taken in
yes,
this
I would
matter?
like to bring you to
It's
this
simply
court's
n-
notice that NPCC, my instruction is that NPCC has filed a review against the SLP. So I have placed one
A review against
So-
the SLP.
Yes. On 25th
You
of
see,
May.
reviews in the Supreme Court is just a delaying tactic,
Yes,
I
yes,
think.
correct. That is
Usually,
correct,
but
Madam.
since it's still pending, it's not disposed of, usually it
It
gets
has been
disposed
filed.
of
It
very
has been
fast.
filed very recently. That is the
But,
yes.
this thing, not officially, but
Yes.
usually a review, unless some very gross,
That is my instruction at this
okay,
stage.
glaring mistake is made,
Yes.
usually, that's what happens. Anyways, so now he has received the instructions that the SLP, there's a review that has been filed. So concerning that, we will fix another date.
Yes.
In the meantime, regarding the newly pleaded respondent number 7,
He will-
because if the Home Department is the one who is to take steps
He
for
will be the best
sanctioning
person to
the
answer.
said amount,
Yes.
then they have to
Regarding the
be
funds.
represented also.
Correct.
Simply calling the other respondents, their excuse will be the Home Department is the concern,
Yes.
isn't
Allow-
it?
allow-
But
Funding
what
authority,
steps
it-
are there, now the steps they are taking is they have filed a review. So, but in the meantime, some positive steps towards the
Respondent number
payment.
7 is the funding authority. That is why we have
But
to.
how are you pushing the funding authority?
Yes.
We have been.
How have you approached the funding authority, informing them of the urgency of the matter? Those steps at least you have to show.
Yes,
What
yes,
steps are you taking
Yes.
towards the payment? Simply saying funding authority, but you were a party in the writ petition. So you have also take a proactive this thing role, so that we'll know that you are really sincerely trying to comply with the judgment order. Simply saying they are there, we are not, that one to this thing.
Allow my lord to make a
Yes,
simple
yes.
submission, my lord.
Uh-huh.
I'm compelled to say this, my lord. This court has been taken for a ride, my lord, because this is a case where the award has been passed in the year 2015. Now it's 10 years. The case has been dismissed by the division bench, and the Supreme Court has also dismissed the SLP.
But since they have filed a
Yeah,
review,
yes.
we'll have to wait for the disposal of the review
Now,
petition.
I
And
beseech-
in the meantime, you see what steps, at least you have to satisfy the court that you are taking sincere steps for compliance by the next court date.
Hello,
And
ma-
if you are not the concerned authority, then newly pleaded, we'll have to see.
We need-
Yes.
Your Lordship will see that in the single judge order, my lord, 4/12/2019, at para 9, it was specifically mentioned, my prayer was specifically mentioned that a fund was already received for the construction of the Indo-Bangla border fencing. So that means the respondent have not taken any positive steps, and they have
So see what
not
steps are
taken
taken.
any real attempt to comply the order of this court. The majesty of this court has to be upheld, my lord. The
But
dignity of this
maybe it is because they had filed an appeal and then they had gone to the apex court. Now, in the apex court also, your case has not been considered. You have filed a review. But I don't think there will be any very high expectation on your part also in a review petition. So don't pay any delaying tactics. Make sure that you show the court of the positive steps you have taken towards the compliance of the judgment and order.
to ensure their bona fide, my lord, the personal appearance of respondent number 5 and 6 may be called. That is my humble prayer.
That's your prayer, huh? Heard Mr. C. Lalfagwala, learned counsel for the petitioner, along with Mr. Roshan Subedi, learned counsel appearing for respondents number 4, 5, and 6. It is also seen that service of notice upon the newly completed respondent number 7 is not returned till date. Full stop. The learned counsel for the petitioner submits that in view of this court's order dated 29/04/2025, wherein this court had clearly held that had observed that, okay, the appeal filed by the NPCC before the Supreme Court and the High Court have been dismissed. Okay, we'll just, from page 63, okay, had observed as following, okay, then within inverted commas. Till page 65, the second last paragraph. The learned counsel submits that the personal appearance of the respondents number 5 and 6 may be called for, since it appears that they are not taking any sincere steps towards the payment of the awarded amount, which is said to have been deposited. Deposited where? Already deposited where?
Not deposited.
Then,
Not deposited.
okay, the awarded amount of so-and-so, okay, 19 crores, 18, it's all here. Then Mr. Subendin Rosi, learned counsel for the respondents number 4, 5, and 6, on the other hand, submits that the respondents have preferred to file a review petition against the dismissal of the SLP, and accordingly has produced the acknowledgement slip regarding the review petition before the Supreme Court, dated 25/05/2025. In view of the above, we may await for the disposal of the said review petition. Meanwhile, in the event of the review petition being disposed of against the review petitioners, the respondents, in terms of this court's order dated 29/04/2025, is to file the so-called affidavit indicating the positive steps taken by them towards the compliance of the judgment and order of this court in WPC number, what's the WPC? 71 slash 2018, dated 04/12/2019. According to list after, yes, 3 weeks?
3 weeks.
3 weeks.
Obliged.
Items 2 to 4.
Lordship, with regard to item number 2 and 3, I've been requested by Mr. Priyanshu Goswami, who is an outstanding outstation counsel. He is unable to appear today, so he had requested me to fix this matter for hearing on 3rd of
Yes.
July.
Lordship,
What's the case date? Let me have a look at the last order.
these 2 and 3 are arising out of a word number 5 of 2009. And by mistake, I have made a statement to the effect that this item number 4 is also part of the same award. But it is not of the same award. It is under award number 4 of 2009.
But item
Yes.
number 2, I can see the name of Mr. A.R. Malhotra reflected in the cost list.
Yes.
So I think 2 and 3, if they are clubbed together, they have to be listed before some other bench, isn't it?
In that
Now
case,
you're
it
saying
may be
that
fixed.
4. Oh, these matters, huh? Cost
This
list
matter
reflects
4 may be segregated.
segregated or not segregated, it cannot be taken up by this court. So we'll have this matter listed before any other available bench.
Maybe
And then you
up
make
next
that
week?
submission in that
Next
court.
week?
Okay. Uh, List these matters before any other bench.
speak to. 4, 4, 6, Lordship.
As
Lordship,
paid for, list
Can
on
we
four
fix a
six.
date? Can we have a fixed date so that can come up? The
So
council?
we're fixing a date 4/6, isn't it?
4/7. 4/7 is the
4,
proposed date.
6 may be in respect of item number 4.
Yes. In respect of 2 and 3, I'm,
Okay, now we'll list it on 4/6 on that day, whichever bench you mentioned, it's next week. On that day, if you want a date and you want to segregate it, you mentioned that. Okay, yes. Never mind, it's a simple matter. 4/6 is a Wednesday, but you can
Yes.
still appear after the DB if there's a DB. Or you want it on 5?
have it on 5th.
Make it 5/6 then.
Yes, 5, 6.
Okay. As prayed for by the councils, list on 5/6.
Item 5.
Yes, may I please, Your Lordship, this is a criminal appeal against the judgment and order dated 29/4/2025, along with sentence order dated 30/4/2025, passed by the Court of Special Judge NDNPS Quezon. By
Okay.
which, yes,
This is not a jail appeal.
not a jail appeal, yes.
See, your grounds is very, very brief, very general.
Yes, madam. I have not produced in specific details.
Simply that the trial court cannot be said to have proved the guilt of the accused beyond reasonable doubt. That's all.
It is simply written, the grounds cited, my lord, but under that there are specific grounds. There is a doubt with regard to the sampling also, and the,
One sentence, grounds for just this. You see, if it was done from jail and they file a simple reason, it's a different matter. But when you're the counsel there, then what is wrong with the judgment? A little bit something, some reasoned appeal. Simply saying that the evidence, the prosecution evidence cannot be said to prove the guilt or beyond any reasonable doubt. That's all.
Yes. Yes, my lord, the evidence is not strong enough to with regard to the presence of the civilian witnesses and with regard to the drawing of samples and
Whether there were any eyewitnesses, at least
Yes,
one or
yes.
two, this thing you should mention, isn't it? In your, this thing, just one
Yes, my
singular,
lord.
you're the counsel, if it was from the jail, it's a different matter. First now we'll see, okay, there's an appeal, what are the grounds, let's see. And then it's, though of course it's a statutory appeal, we'll admit the appeal, but when they have engaged a counsel, we expect a slightly more, what would I say, reasoned grounds should be given, isn't it?
yes, my lord.
Anyway, I heard Mr. Planet Counsel for the appellant, who has filed this appeal under section 374. When was the incident? Okay, it should be actually CRPC. Okay,
Yes.
374 CRPC. You have made it red with 415 BNSS against the impugned judgment and order dated 29/04/2025, along with the sentence order dated 30/04/2025, passed by the Court of Special Judge, NDNPS Act, in connection with excise case number 63/2017, dated 22/03/2017, under section 20B within brackets 2 within brackets C of the NDNPS Act, wherein the appellant was convicted under section
20B to C.
20 within brackets B within brackets 2 within brackets C of the NDNPS Act, and sentenced to undergo rigorous imprisonment for a period of 10 years and also to pay a fine of rupees 1 lakh ID, rigorous imprisonment for another 10 months. Appeal is admitted. Issue summons to the respondents. Mrs. Vani Siami, Ms. Vani Siami, learned additional PP, accepts notice on behalf of the state respondents. Requisite copy of the appeal memo to be duly furnished to the learned additional PP. LCR is to be called for. List after 2 weeks. Make it TCR, okay, not LCR.
Order. Item 6.
Yes, obliged, my lord.
Yes.
Your Lordship, this IA is for intervention and impleadment of the present applicant in the present writ petition. Being the necessary party, my Lord.
Worship, we will be filing our objection within the course of the day.
This is in fact simple matter, Your Lordship.
So now who is the respondent?
Respondent is the in fact the
Respondent in
state,
the main case is the state only, my lord.
and I'm the applicant, man. Applicant in the IA.
So now, here in the last court date, the respondent, they filed their written objection, if so advised. So are you going to file?
Yes, my lord, we will be filing within the course of
You
the
are
day.
the,
I am for the writ petitioner, and I am the opposite part, respondent in the
but if you are
IA.
the applicant should be
Yes,
here.
that is what I'm thinking,
You're-
my Lord.
you're confusing
Since,
me,
Yes,
isn't it?
exactly. Since, yes,
You are the applicant.
if IA is to be taken up, I should be here, my Lord. Sorry for
Yes.
that.
That's why I was just thinking what's going on. Anyways, so now, the private respondent or the private opposite party wants to file their written objection.
Yes,
Is
my
it-
lord.
Then we'll give them some time.
My lord.
Mr. Bila Ramena, learned counsel for the applicant, is present along with Miss
Laropari.
Ropari, learned counsel for the private, is
Yes,
it?
my lord.
Private opposite party number
No.
in the IA. How
One,
many
my
private
lord.
parties?
One.
One.
Okay, number? Two.
One.
Res-
What?
One.
One. my lord.
One. And Mrs. Caroline K. Lalumurthy, direct government advocate for the state opposite party. The learned counsel for the opposite party, number one, has paid for time to file their written objection. Praise aloud. List after 2 weeks.
Obliged.
So obliged.
Item 7.
Yes, time was given to file a impleadment, written objection, any?
Yes, my lord. I have submitted this morning, my lord.
So we list it when? It's not here in the file. On Monday?
Lordship, let this matter be taken tomorrow.
Okay, if you're ready, we can take it up tomorrow. Because I think it's a small matter and we're simply giving you time to file a written objection. Mr. Sila Ramzawa, learned senior counsel for the applicant, is present along with Mr. Ricky, is it?
Yes, my lord. J. Ricky Lalwatfela.
Ricky Lalwatfela, learned counsel for the opposite party. The learned counsel for the opposite party submits that they have filed their written objection this morning. It is seen that the said written objection is not available on record. In view of the above, list this matter. Tomorrow's date is what, on? The next date. Tomorrow's date, yes.
30th. Item 8.
May it please your lordship. Lordship, in compliance with the last court order 19/5 of 2025.
Newspaper publication affidavit file,
Yes, lordship.
which newspapers?
One new Vanglini and Newslink.
Newslink, dated?
Dated April 9, Wednesday.
Okay, now the concerned respondent number 6 and 7, they are the residents of which place? They are the residents of Bongkon, is it?
Bungkon, Vancouver.
Okay, Bungkon and Sterkon.
Sterkon.
And 6 and 7 are what? The owner and the driver?
Yes, lordship. Owner and the driver of the Maruti van.
Okay. Heard, Mr.
Michael Patel.
Yes, heard, Mr.
Michael Patel.
Michael Pachal, learned counsel for the petitioner, who submits that the newspaper publication has been made and affidavit to that effect is filed. Full stop. On perusal of the affidavit filed, it is seen that the newspaper publication has been made in the two local newspapers. Vanglini dated
9th of April.
9/4/2025, and the other one?
Both 9th.
The other one is which newspaper? It's all clipped together. Okay, Newslink. is it?
Newslink. Yes, lordship.
dated so and so. The same date, okay? In view of the above, notice is deemed to be complete upon respondents number 6 and 7. None appeared for the respondents.
My Lord, for the respondent number 1 to 4.
Okay, Mr. So-and-so appears on behalf of respondents number 1 to 4. Now, so LCR is received, full stop. It is seen that LCR is received, is it? And since respondents number 1 to 4 is duly represented, what about 5? Who is respondent number 5?
Respondent number 5 is the owner of the Alto, the other vehicle. And they have not filed their written statement in the learned tribunal.
So should we strike off their names of respondent number 5? 1 to 4 is duly represented. It is also seen that respondent number 4 had not appeared before the learned
Number 5, my Lord.
tribunal.
Respondent number 5.
Respondent number 5 had not appeared before the learned tribunal. Therefore, the learned counsel for the appellant has prayed that his name may be struck off. Praise Allah. Name of respondent number 5 is struck off. Matter may be listed for hearing in due course.
My Lord, if it can be taken up after a week for admission hearing.
Appeal is already admitted, should be admitted, not yet admitted or what? Usually, MAC appeals are admitted, let me see, not yet admitted. No need of an admission hearing, we list for hearing. Appeal was admitted on 11/9/2024. Just make it sense, appeal has already been admitted, matter to be listed for hearing after 2 weeks.
Item 9.
Yes.
Yes, Your Lordship, as per the last court order, notice upon the respondent number 2 has been waited.
Okay, so number 2. Who is number 2?
Number 2 is the owner of the accident vehicle.
So their presence is required in the appeal?
Yes, because the insurance policy is not valid.
Okay. So what do we do? Can you serve notice through Dusty?
Yes, Your Lordship.
Mr. K. Laldin Liana, learned counsel for the appellant is present.
Lordship, if I may be allowed to make one prayer, the instant MAC appeal number 2 along with MAC appeal number 1 and 3 of 2025 are an analogous case.
Which one is that? The previous one, the one which we just passed?
No,
over?
Your Lordship, the previous one was taken up on Monday, 26th.
What previous?
MAC appeal number 1. The
MAC
instant
appeal
case,
number 1 is not listed today.
no, Your Lordship, it was listed on Monday. And the instant case is MAC appeal number 2. And along with MAC appeal number
Okay,
3.
wait, let me pass the, yes. Mr. Learned counsel for the appellant is present, along with Mr.
Michael Pacho.
Michael Pachaw, learned counsel for respondent number
1.
1. It is seen that return of service of notice from respondent number 2 is still awaited. So the learned counsel for the appellant submits that he may be allowed to serve notice to respondent number 2 through Dusty Mook. Praise aloud. Learned counsel for the appellant to take steps for service of notice upon respondent number 2 through Dusty mode, and affidavit to that effect is to be filed accordingly. Full stop. The learned counsel for the appellant, for the respondent number 1 submits that there is an analogous matter registered as MAC appeal number
1, 2, and
of
3.
MAC appeal number 1
1 of 25.
of 2025 and
2 of 2025 and 3 of 2025.
this is what? This is
This
2.
one, this one is true, yes.
So there's a MAC analogous matter, MAC appeal number 1 of and MAC appeal number 3 of 2 and 2025. And therefore pray that these 2 MAC appeals may be listed along with the present MAC appeal number 2 of 2025. In view of the above submissions, the said MAC appeals, MAC appeal number 1, MAC appeal number 2, and MAC appeal number 3. Okay, make it all of 2025, all to be listed together. List after 2 weeks. List these matters after 2 weeks. Yes.
Thank you, Your Lordship.
Item 10.
Yes. Bail
Your Worship.
application.
I believe that the learned counsel for the petitioner is not
Okay.
present.
Mrs. Mary L. Kiante, learned additional PP is present while none appeared for the petitioner. In view of the above, list after 2 weeks.
Item 11.
None appeared for the parties on call. Oh, this is a application made.
Counsel's name are not reflected, madam. So,
This is an application for bail filed from jail.
from jail.
Then we'll have to appoint an amicus.
Yes.
But I don't think we should encourage this sort of a trend. Straight away from the bail, from jail, they apply for bail.
Yes,
Others, and every time we'll have to. So let's see, this is matter tomorrow. Just look at the matter, this thing, study whether we should this thing file an amicus also in such matters. Bail applications, straight away from jail, and we appoint an amicus here. I don't think that would be very appropriate. We'll
Yes.
be encouraging something which didn't be done. So we'll look into this matter. Okay, this is matter tomorrow. This.
Item 12.
May it please your lordship.
Yes.
Your
What is
lordship,
the IA about?
Your lordship, the IA is about filing an additional evidence along with the first appeal under order 41 rule 27. So actually your lordship, there is some misunderstanding. The IA actually it should have been listed in the admission column because the case is listed today for the first time. It is the first appeal. Usually it gets listed in the admission column.
So anyways, no, this should be in order because this is an IA. IA's come for the first time, so we'll have to pass an order. Besides the order, nothing else to be done.
No, your lordship, the IA has been filed along with the first appeal. The IA is not for
Even then, the IA, your system, you have come from which high court?
Guwahati.
Guwahati. So the way they file here and here will be a little bit different.
Yeah, no, if your lordship will allow me, I'll just explain what has happened. So I have preferred a first appeal.
Okay, so since the matter is lifted for in the orders column, as paid for by the learned counsel, listed in the admission column, list after 2 weeks. Yes.
Your lordship, if I may, I have traveled across. So
Then
your
you'll have to
lordship-
travel again if you're making that objection.
No, I'm not making objection, just a humble submission. If your lordship will just.
So let it be listed in the admission column and list it after 2 weeks. Okay.
For
Yes.
hearing, item number 3. 13.
My lord, if I may make a small submission regarding item 1 of part 2, which was adjourned this morning.
Already adjourned?
Yes, my lord. I was not here when it was adjourned. I apologize. But I want to make one small submission regarding this matter, my lord. This is a jail appeal. It is not a. This is not a jail appeal. This is an appeal by the state against the acquittal
So
order.
we have listed for which date?
Next week, I think. But my lord,
Which date is it, item number?
it's today. It's today, but it's been adjourned.
Huh.
What I want to mention is that, my lord, no notice has been sent to the respondent. So he may not be
It's
a,
been listed for hearing, so obviously notice must have been
No, my lord,
sent.
it's a jail.
Notice must be complete.
no, my lord, no notices. He's not a party in the,
My lord, this is
That-
an old case, so we have not made the complainant a party. If it's required, we can take Dusty.
Let's see, how can it be listed for hearing in the whole hearing column?
This is like, my lord, 2019 case, so we have not made them a party. We have.
so he
missed
may
out.
not be aware of the case being filed against him. So he may want to engage a counsel of his own. He has not asked for a legal aid.
Wait, let's see. Because even if it's a 2019 case, no, the learned counsel for the appellant is allowed to serve notice upon the respondent by Dusty service.
My lord, the respondent is the present respondent here.
I'm the amicus,
Respondent
my
number
lord.
2.
Through Dusty.
Yes, my lord. I received the
So
copy, but he may not have received the copy, the accused.
you're the counsel.
But
Make sure,
but he has not asked for a legal aid, no.
even if you have not asked, see,
Right?
the notice
You're
was
the victim.
served through Dusty mode.
Yes, my
Okay.
lord.
Then let's see, what were the previous orders? So then 2 weeks,
If
3
it's
times
the-
was, time was sprayed to file affidavit of service on the respondent.
My lord, I was straight away appointed, and he may not know about this present case. That's the point I'm trying to make
No, we have already served a notice.
Service of notice is complete.
on the respondent.
Yes.
I'm one victim.
Learned additional
Yeah.
PP has served notice upon the respondent through Dusty mode, and this court has observed that service of notice upon the respondent is complete.
All right, my lord. Then.
Is it? Otherwise, it won't be listed for hearing.
Yes.
Yes, my lord. Because, my lord, the accused had engaged a private counsel in the trial court. So I assumed he might want to.
Don't presume. Read the records and see what's going on.
I
Okay.
apologize, my lord.
Simply coming and making some vague accusation. Yes.
For hearing, item 30.
Yes.
May it please your lordship. In the last court date, there was an issue with the applicability of the CPC.
Yes.
Whether it's in spirit or whether in toto.
Yes. So you said that you were not prepared
And
and you wanted to have
Yes,
some authorities to rely
yes,
upon.
I want to bring on record the 2007 amendment.
Before that, you said that you were not the previous counsel and you do not receive a copy of the written statement.
Yes, a
So
copy
now
of the written
have you
statement was
received
not.
a copy of
Yes, yes,
that?
my lord. It has
Okay.
been served to me.
Now, what is the appeal about? Against the judgment of the,
The
I think
appeal,
before really going into the merits of the case,
yes, my lord.
you had said that they did not receive a copy of the written
Yes, they filed a
statement,
written
and
statement
therefore you
in
had
appeal.
prayed for another date. Now,
Yes, my lord.
since all the documents are duly furnished to you, I think we can look into the matter.
Yes, my lord. This matter pertains to land dispute. And the court of J.S. Chakma, Judicial Officer District Council, Chakma Autonomous District Council, Kamala Nagar, had passed the impugned judgment dated 21st October 2021. And being aggrieved, the appellant is before this court. The grounds of appeal, amongst other things, is that no issues were framed by the said judicial officer while dealing with the case. And in this regard, I have submitted one authority in the previous court date, wherein the single bench of this honorable court, while relying upon the division bench,
Okay.
decision of the division bench, has held that framing of issues is mandatory. And there was an issue with regard to the applicability of CPC, whether it's in letter or in toto.
Yes, now I'm recollecting her.
Yes. And in the 2007 amendment, my lord, I have given a copy to the bench assistant. Page 4, my lord.
Yes.
Amendment of section 21. Subsection 1 of section 21 of the Principal Act shall be substituted as follows. Number 1, subject to the provisions contained in subsection 3 of section 1 of the Code of Civil Procedure 1908. The procedures prescribed in the code shall, save insofar as otherwise provided by this act, be followed in spirit in all civil courts. So the CPC is applicable in spirit here in Mizoram. And the contention raised by the respondents is that since it's an autonomous district council, the CPC is not applicable to the letter and is followed in spirit. So we are basically at the same footing. And the decision of this Honorable Court in RFA number 11 of 2017 will also be applicable in the instant case as well, my lord.
Okay.
Paragraph number 6, my lord, the operative person starts from paragraph number 6. If I may be allowed to read, my lord.
Yes.
This court is not going into the merits of the case, but only going into the question whether the learned trial court would have disposed of the declaratory suit without framing any issues or taking any evidence. Number 7, in the case of Akhil CH Datta versus Anil KR Datta reported in 1998, volume 2, GLT 105. This court has held that justice must not only be done, but must also appear to be done. In the case of Akhil CH Datta Supra, this court has held that a case may be disposed of on a preliminary issue as laid down under Order 14, Rule 2 CPC. And if the court is of the opinion that the case or any part thereof may be disposed of on an issue of law relating to A, the jurisdiction of the court, or B, a bar to the suit created by any law for the time being, enforced by postponing the settlement of the other issue until after the issue of law has been determined. In the case of Supreme Enterprise, MS versus H3 Marketing, MS and others, reported in 2011, Volume 1, GLT 133, this court has held in Para 11 as follows. In view of the aforesaid position, this court is of the considered opinion that unless all issues, including preliminary issue, is framed in terms of Order 14 or Rule 1 after filing and the reception of the pleadings of the respective parties, the same being mandatory, a preliminary issue cannot be framed separately, but once a preliminary issue has been framed along with other issues, then the court is under an obligation to decide the preliminary issue first, and if upon decision on the preliminary issue.
Yes, I've got your point, huh?
Yes, yes.
Anyways, so let's say the judgment, impugned
Yes.
judgment, issues were not framed.
The impugned judgment is just after the index. And a perusal of the judgment goes to show that no issues has been framed, my lord. Issue of fact or law.
This is a judgment by the District Council Court, isn't it?
Yes, my
Chakma
lord.
Autonomous District.
Yes, my
Oh.
lord. So in my humble submission is that issue of law or issue of fact is mandatory, and the same should have been framed before the trial court decide to proceed with the trial of the case.
Okay, that's all?
And
You don't want to look into the, decide the merits?
merit wise, my lord,
Discuss the merits of the case? Or you,
Merit-wise, I don't think it will be necessary in as much as issue will have to be framed and the case will have to be decided on merits in the trial court. And one other aspect is that, my lord, the London trial court had failed to implead the revenue and land revenue and settlement department.
Then you will have to go into the merits to see whether, why should the revenue department be
Because
impeded?
it's a land.
What is the land dispute? So what is
Yes.
the nature? All land disputes, it's not automatic
my
that
lord.
the revenue department has to be impleaded. What is the nature of the dispute?
My lord, the nature is with regard to the encroachment.
Okay,
The
encroachment.
reason that I am raising this issue is that a direction has been made against the land revenue and settlement department who are
Okay,
not party. in this.
where, in the judgment? Why was a direction made against the land revenue department? What is the case about?
The direction,
Why was the direction made?
The direction
What is
made-
the case about?
the case is about encroachment of land.
Who is the
pass.
land?
Pardon, my lord.
Whose land was encroached?
The respondent contended that my land pass had encroached
Where
upon
was,
his
where is he having his
heartland.
land?
In Kamala
Respondent number, how many,
The sole
sole
respondent-
respondent
sole
has
respondent.
having his landed property where?
Kamala Nagar, my lord.
See, your submission, it's not as if automatically this court will say, okay, we'll not go into the merits because there's a judgment.
No,
That is for the
no.
court to decide. So at least tell me what are the facts, why have you
Yes.
come on appeal?
My lord, we have read out the judgment in the previous court date, so
We touched so many cases.
Yes,
Now
yes,
I'm
my lord. I
literally
apologize. I
with
apologize.
Bits and pieces only, huh?
yes.
I don't think this judgment was ever read out.
The contention of the respondent in the case is that her land has been encroached by the present appellant who have,
Okay.
without her knowledge, have extended his revenue pass by unfair means. And accordingly, she filed the suit. And the facts of the case in brief will starts from paragraph number 3 of the judgment, my lord. It's quite a lengthy.
So without reading, just tell me the brief facts. She's having landed property where?
Kamala Nagar, my lord.
And
And
then what happened?
the land of the petitioner and the respondent are adjacent to each other, my lord.
Okay.
And her contention is that this present appellant, who is the respondent therein in the trial court, had increased the area.
Defendant. Okay, defendant in
Yes.
the trial court.
Yes. Had increased his area of land from 6 feet from 24 feet to 34 feet, thereby encroaching upon her land. And it was also the contention of the respondent that this was done by unfair means. The present appellant had denied to the allegation made by the respondent, and he had also stated that no unfair means was done by him and that his pass
Okay.
is correct. Thereafter, the trial court, without framing any issue, had taken some evidence which are not legible. It has been enclosed in the written statement filed by the appellant, but I am unable to read it. It can be seen from,
Evidence not legible.
yes, my lord.
Where?
It's very difficult to read. It will start from page 22 of the written statement filed herein by the respondent. And no type copy has been provided. And
So
if your lordship can
have we
see,
called for the LCR?
LCR has been called for,
Oh,
But
So
paper
let's see the LCR.
yes.
Hmm. Showing the LCR, the evidence will be here, whether it's legible or
Yes.
not.
My lord.
Then we'll have to see this evidence.
Yes, my lord.
No,
And,
no, 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 no.
my lord.
This is statement of Latubar Chakma.
These are all very difficult to read. my lord. And if your lordship permits, this appeal can be disposed of at a technical issue only, my lord. If your lordship permits.
Okay, that's, okay, yes. What about the rest? Do you agree?
My lord, I have a submission regarding the applicability of CPC in spirit
okay.
or in letter, my lord.
Yes.
My lord, co-counsel have submitted a written statement in which it was stated that the Poilakher Autonomous Region Administration of Justice Rules 1954 has been applicable.
1954,
Yes,
yes.
my
Not
lord,
the
I have
civil
not been
courts,
requisitioned, but I have prepared a copy, my lord. May I submit
Of
that
what?
rules? Yes, my lord.
Of what?
For the regarding the applicability of CPC only in spirit, not bound by the in letter. Okay. So, my lord, may I submit these rules? I have
Okay.
not
You're
requisitioned.
you're going to read that or
Yes,
what?
yes, my lord.
Okay, you want,
My lord,
what is that?
that is the Poilakher Autonomous Region Administration of Justice Rules 1954.
1954,
Yes.
okay, yes.
My lord, the relevant portion is at page 162,
Yes.
Rule
160.
41.
Huh.
In all civil cases, the procedure of regional council court shall be guided by the spirit, not bound by the letter. The Code of Civil Procedure 1908 in all matters not covered by recognized customary laws or usage of the region. Now, my lord, in coming to, if I may take your lordship to page Rule 39, my lord. Rule 39, sub Rule 1.
39.
Yes, my lord. Rule 39, same page, my lord.
Yes,
Sub,
yes.
yes. In all civil cases, the regional council court shall adjudicate according to law, justice, equity, and good conscience, consistent with the circumstances of the case, my lord. So the district council court,
So read
Yes.
the second one
second
also.
one, it shall be discretionary to examine witnesses on oath or affirmation in any form or to warn them that they are liable to punishment for perjury if they state that which they know to be false. So, why discretionary has been given to the judge in the district council court, my lord. So, according to their good conscience, they can adjudicate the matters also. So, my lord, here in the CPC 2007 Amendment Act that my learned friend had read out, so that the same provision has been added in Section 21 of the Mizoram Civil Codes Act 2005, my lord. If I may read, my lord. Subject to the provisions contained in subsection 3 of
You're
section.
reading from where? Civil Codes Amendment Act
Yes.
2007? Okay.
No, my lord, that's the Act, 2005 Act. So that 2007 amendment.
Wait, I don't have the 2005 Act with me. Wait, you will give it. Yes, here.
Section 21, my lord.
Yes, 21. Yes.
Okay, may I? Subject to the provisions contained in subsection 3 of section 1 of the Code of Civil Procedure 1908, the procedures prescribed in the code shall, save insofar as otherwise provided by this act, be followed in spirit in all the civil codes. But, my lord, here, not bound by the letter is silent. So, in District Council Code, the letter is not bound, only in spirit. So, my lord, if we going to, if we
So
go
if you
in,
look at
yes,
this will be section 1, short title, extent and commencement. Okay, Civil Courts Act.
yes,
It extends to the whole of the state of Mizoram, excluding the autonomous district council areas.
yes. But, my lord, subject to the provisions contained in subsection 3 of section 1 of that CPC. My lord, I think we need to look into section 1 of subsection 2 of the CPC, my lord.
Yes, CPC. And anyway, the Civil Courts Act is not applicable for the autonomous district council.
No, my lord, subject to, we need to look
yes,
into CPC.
Yes. CPC,
Section 1, subsection 3.
so for the appellant, besides this point on the merits, he has nothing to say.
Yes, my lord.
Okay, but you have something to say on the merits of the case, is
Yes,
it?
my lord.
Whether it's a reasonable judgment. Okay, good enough.
May I read, my lord?
Yes.
Section 1, subsection 3. It extends to the whole of India, except the state of Jammu and Kashmir, B, the state of Nagaland and the tribal areas, provided that the state government concerned may, by notification in the official gazette, extend the provisions of this code or any of them to the whole or part of the state of Nagaland or tribal areas, as the case may be, with such supplemental, incidental, or consequential modifications as may be specified in the notification. My lord, so
So
the
it's not been
exception.
extended,
Yes.
it's to be applied only in spirit. That's what you, both of you are
So,
saying,
yes,
isn't it? Huh?
yes, this is there is one inconsistency or repugnancy between the laws made by the state regarding the applicability of CPC in letter. So the CPC
No.
does not exempt the state of Mizoram.
See, the submission
No,
of the learned
tribal
council,
areas,
the
yes,
the
please.
submission of the learned council for the appellant is that the CPC is also applicable only in spirit.
Yes, my lord.
In the civil courts.
Yes,
Okay, since it's applicable only in spirit,
yes,
knowing that the judgment of a coordinate bench of this court
Yes.
had said that even issues should be framed anyways.
yes, my lord.
Are you getting?
Yes.
So it's not his case that it is not applicable in, it is applicable, it is not applicable in spirit. It is applicable in spirit, but even then, the coordinate bench of this court has said that issues have to be framed. That's the submission.
So, yes, my lord, that is why there is inconsistency between the CPC, the Principal Act, the laws made by the center and the state. So, my lord,
So if you're going to challenge the laws made by the state, it cannot be done by a single judge. It has to be before the division bench.
yes, well, regarding the applicability in spirit or in later. So, Yeah.
It's in both spirits, so how will it be different? I don't get his point.
No.
It's both applicable in spirit in the Autonomous District Council as well as in the Civil Code of
That's what
Fire.
I'm explaining. That's
Yes.
what that. So,
just don't get his
but his point is that simply saying that it is not applicable in spirit cannot be done because it's not as mandated by the CPC. If it's challenging the Civil Courts Act and that, then it's a
So,
completely
my lord, by
different issue. It cannot be considered in the RFA.
Yes, my lord, my humble submission is that according to the
So according to you, it is
administration of justice
applicable
rules, yes.
in spirit.
Yeah. Yes, only
Okay,
in
in
spirit.
spirit.
It is not bound by the letter. So
Ah,
according
so
to
it's
their
spirit,
rules,
ah.
yes. So that is clearly stated in the rules, my lord.
Yes, okay.
Yes.
So
And
that
then-
issue is done.
Mm.
Now, let's look into the merits. So do you,
Yes, my lord.
besides that, you have a good case in the, as
Yes.
per the merits, it appears.
Mhm.
Because the counsel for the appellant has not raised any issue concerning the merits of the case.
Yes, my lord. The story I just want to point it out briefly, my lord. So I have a landed property at Kamalanagar,
Yes.
which is pass number 8 of 88, and in the original defendant, appellant, has a landed property adjacent to my land, which is pass number 34 of 83.
Okay, yours is,
So-
yours is? Your
Well,
pass number
Pass
is
number 8 of 88.
8 of 1988. Then
Yes.
later adjacent to you is another pass number?
34 of 83.
Oh, but he's the one who had it
Yes,
before
older
you.
than mine.
Oh, so
But-
you came later?
Yes, yes, my lord. But my lord, so the issue is that the while I was in Delhi, so the appellant constructed a house within the within my plot of land. So that is why I have made a complaint to the district council court. So and then the district council court called all the record of the revenue, and then while inquiring, perusing the pass of the appellant, so third 24 feet has been, there is rewrite again. So, third 24 feet has been increased into 34. That is clearly visible in the KC court also, my lord.
Let's see the, let's
Yes.
see in the judgment, it was observed like that?
Yes, yes, my lord, yes. And then, my lord, before I'm going to the
Yes, yes,
findings.
okay, okay.
So, and then after that, Satya, I forgot his name, my lord.
No, take your time, there's no
Mhm.
need to worry.
Satya Priya Dewan.
Hmm.
He is the son-in-law of the appellant. So he was working at revenue office. So that is why there is some, maybe
Son-in-law
that
of the
thing that
appellant.
conspiracy
Okay.
regarding this increase of land. So then he was called as a witness, and then he admitted that he was working as a revenue department. He was dealing with the temporary pass only, and then the appellant pass has been converted into. Before that, his land pass was a temporary pass, and then was converted into a settlement.
Okay, he stated all that in his deposition before the court? He
yes,
appeared as
yes.
witness PW number, must be DW,
Oh yes.
defend witness number what?
I think, my lord, we can clearly see from the findings of the trial court. So before going to the, my lord, so he clearly admitted that he issued the pass. He put his initial.
Okay.
And then
The
after
trial
that,
court observed that?
yes, yes.
Okay.
And then after that, the learned trial court directed the revenue department to conduct a verification of the land dispute.
Okay.
And then the revenue department conducted a verification and then submitted a report to the district council court. So that it was clearly seen that the present appellant has increased his land. That is why the respondent
The report
land,
of the revenue is there?
Yes,
Is it?
yes.
Revenue report
yes.
exhibited or what? By
No,
the trial court or what?
I think, my lord, it is not exhibited, my lord, but it is clearly seen in the judgment at
Okay, the
Roman 8.
judgment says
Yes.
depended on the report of the revenue department.
Yes, my lord. So that is why the
Okay, any officials from the revenue department made a witness?
no, my lord,
The person who made the report, nothing?
nothing, my lord. They merely submit a report, my lord.
So was the report, is the report available?
My lord, it is reflected in
Just the judgment, is the
yes, in the
report?
judgment.
Okay, but the report is not in the file?
Yes, my
of
lord,
the-
because paper book has not been requisitioned by the.
Then, if there is no paper book and you are depending on some documents, I think paper book has to be prepared then. Because now you're saying in your submission, you're saying that there's a report.
Yes, my lord.
Now, whether the report was filed in the court or not, you don't know.
My lord. But the clearly reflected in the judgment.
In the judgment,
Yes, my lord.
then even if it's reflected, this is appeal against the judgment. So we have to look at the report also, isn't it? And where's the report? We don't know whether the report is there or not. Then we'll have to prepare the paper book also and see whether the report, you have to see the report also. You have to make his case strong. Because the appeal is against the judgment and order, so to make your case strong, you have to show the court, here's the report is correct, this is the report, based on this, the judgment, learned trial court has made the decision, there's no reason, isn't it?
My lord. My lord, so it's a long pendency since 2020. The case has been pending. So if the matter may
See if
be
the
remanded,
report is there.
sent back to the for
What? Send
framing
it
of
back
issues.
for
Yes.
what? For what?
So as per my learned friend has.
So
prayed
you're
for-
not contesting his submission?
Yes,
At
also
least
let-
come to
yeah.
that. Okay,
Because,
so
no.
both the parties
Yes.
have prayed for remanding the matter back since no issues were framed. Is
Yes,
that
my
simple
lord.
as that?
Yes, my lord. And
Then why did you?
Because there is no
Anyways,
report available, my lord. I'm sorry for that.
Don't argue for the sake of arguing. If you also want to concede to the submission, just make it straight away. Isn't it? Then we will not say anything on the merits of the case. Because him simply saying no issues were framed, that doesn't mean automatically this court will say yes, no issues were framed. So I wanted to hear your side, whether issues should have been framed or not, whether in the CPC, maybe you could have come up with some other authorities where issues, when the merit itself is not been, appears to be challenged, but he's not made any submission on the merits also. But both of you are now agreeing that issues were not framed, let the matter be remanded back. We'll dispose of accordingly because at a little bit before 12, this court has to rise. We have to see of the farewell, the program of the Chief Justice is going to take place at 12, so we have to attend through VC.
yes, my lord. And
So I'll pass the order later.
yes, my lord.
It will be at 12, another 5-10 minutes. I have another 5 minutes. Yes.
Yes, my lord.
So I'll pass the order later, remand it back for
Yes.
framing of
And
issues, not
for
challenge.
Framing of issues on question of fact and law, my.
Yes, yes,
Yes,
that obviously, yes.
May I make a humble submission?
Yeah, what?
Your Lordship, will it be possible to fix the matter tomorrow on the admission column? Humble request. Your Lord. Item number 12,
For what now?
first appeal.
See, you decide that with the registry. Okay, whether it should be listed before the order or the admission column, because we'll have to look at the High Court rules, and that is not for this court to see. So with the registry, learned counsel of Mr. What's your name?
G.R. Datta.
So and so, learned counsel for the applicant submits that this matter appears to be listed in the wrong column. The learned counsel is advised to take up the matter with the registry and matter be listed tomorrow's date.
Deeply obliged, Your Lordship.
Yes.